Sorry. Okay, so hi everyone again. I'm Nancy Hoffman-Vaniak. I'm President and CEO of the Greater San Fernando Valley Chamber. Thank you so much for joining us today for the 2026 Labor Law Update. We have an amazing speaker, Kristina Kourasis, who I'll introduce shortly. But before we get started, I want to do a quick poll um, where you're just going to do it on your computer. We want to know how many employees you have, and you just have to put the number in there. It's not like not check the box. So I'm going to launch it and then we'll give it we have a lot of people here, hopefully less than a minute that you can go in and let us know how many employees you have, just so we have an idea. Because that also helps guide us on how we help you. And while you guys are filling this out, if you don't have a 2026 labor law poster, we do have them available.
Change.
They've been entered. Hey, Nikki, can you do me a favor? Can you mute everyone and then unmute me and Kristina?
You bet.
Thank you. So if you don't have a 2026 labor law poster, we do have them available on our website. If you're a chamber member, you will receive one free, but you do have to order it. If you did not order it from us, we could send out that link, or we could put both the links in the chat later on. And still a few more people taking the survey. So I want to remind everyone, you do need a new one. We will have ours next week. They arrive hopefully Monday or Tuesday. If you're attending our Network Connection breakfast, hopefully we'll have them in time to bring them there. If you've ordered them to be picked up, or if you ordered them to be mailed to you, obviously we'll get them in the mail. Let's see, is everyone still taking the survey? Just a few more. And we have this meeting scheduled till 11:30. But we also that's to allow for questions. If it ends early, you get part of your day back, because normally we're done within an hour, but every now and then it lingers on. Okay, I'm going to end the poll. And I'm going to share the results. Is it sharing it? I have no idea what's it doing. Can you see the results?
Not yet.
Not yet, even though I say it's sharing. That's weird.
I see my answer.
You see your answer.
Mm-hmm.
Okay, give me 1 second, because I actually have it on the screen too. Okay, where'd my screen go?
There we go.
So you can see it now? Okay, so, oh my God, I have the little one open too. Okay, so I'm sorry, it did not compile it all for you, but it did give us this little separate appeared how many times, how many answers are. So all answers, answer one. I don't know, this is a new format for them. So, but we kind of have an idea that we have people here with small businesses all the way up to like 800 employees. So, or 1,200 employees.
1,200.
So, yeah. So, no, 3 employees appear 1,200. Yeah, 1,200. 3 people have 1,200 employees. So, as you can tell, there's a wide range of people in this group, and Kristina's going to try to answer all those questions, because different size businesses have different issues, even though the laws still affect pretty much everyone except for issues that are with over 50 employees. So with that, I'm going to introduce our speaker. So our speaker today is Kristina Kourasis, attorney at law. She is with the law firm Landegger and Verano. They're the employer's lawyer. She has done this webinar for us for, I don't even know now, Kristina, what, 10 years?
Probably close to.
Yeah. And she has extensive experience representing employers in a wide array of industries such as healthcare, retail, manufacturing, finance, hospitality. I could go on and on, including nonprofits. She was very instrumental during the PAGA, the Paid Attorneys General Act, when all those modifications and what do I want to call it? When we finally came down to where they were drilling down the bill so it wouldn't be so onerous for businesses. She's definitely your go-to person from everything from your employee handbook to, God forbid, you're being sued for something. So I could go on and on and on, but I will put her bio in the chat. Give me 1 second. My screen looks totally different since I did this update today. So sorry, that's taking me like really weird to find everything. So with that, I'm going to share Kristina's screen. My whole screen's like it's not white anymore. It's very weird. It's not black. I'm going to share the screen, and then we're going to let Kristina get started. Let me get it going for you in the right way, Kristina.
All right.
Okay, and just tell me when you need it changed.
Okay, cool. Uh, Good morning. California employers don't need more laws, do we? We just need more clarity. So my goal today, just like every year, is to walk you through the 2026 labor and employment changes that actually matter to your business and kind of what the practical implications are and how do we stay compliant. We can go next slide. Okay, so the first thing that I always talk about is the minimum wage updates for the state and for the city of LA. So the minimum wage for the state of California is $16.90 per hour. That's effective January 1st, 2026. And the minimum salary for exempt employees is just a little over 70,000, 70,304. And I have the monthly figure here for you as well, if you need that.
No, I'm not on video. It's just like a listen only.
Next slide.
Please make sure that you're
Okay.
mute.
Next slide. There we go. We also always talk about the local ordinances because those trump based on the city where you're doing business. So for the city of LA, that's the only one I'll discuss today. The minimum wage goes up to $17.87, and that's effective July 1st, 2025, and it goes up every July. Next slide. There's also industry-specific minimum wage updates, and we know for the LA hotel worker, that wage goes up to $22.50 per hour. For healthcare workers, there's a multi-tiered increase depending on the type of facility. It's a very extensive piece of legislation that I know many of you already spoke to me about. But just be aware, and if you have questions, do reach out. Next slide. Okay, so this is a big one because for a lot of our clients, they tend to be nice to their employees and they tend to give them free perks. And one of the biggest one is like, we'll train you for free as long as you stay for at least a year, right? And so guess what? You can no longer do that. If the training is something that the employee is required to have to be able to perform their necessary job duty. And so the stay or pay provisions, as they're called under this new law, are simply not lawful anymore. And so now you can still offer things that are perks and benefits as long as they're not the essential part of what the employee performs for you. And I'm sure I'll take a bunch of questions on this. Okay, next slide.
But can you just explain that a little better?
Yeah, I mean, it seems more complicated than it really is. What this really is I'll give you an example. So if, for example, a healthcare worker requires certification to be able to perform their job duty for you, you can no longer condition a free certificate program on them staying for a certain period of time. So you can no longer say, okay, we'll pay for your certificate program as long as you stay with us for at least a year. Now, if it's something else, for example, oh, you want to have this additional credential that's not required for you to be what you are for us, let's say it's a healthcare worker. We don't need this extra certification, but if it's just for you to become, more advanced in your skills or whatnot, then you can still condition that as a perk. But the main distinction is that it's not a prerequisite to performing their job duty for you. If that's the case, then you're no longer able to condition, this contracted obligation to repay this debt. Does that help?
Yep.
Okay. Yeah. All right. So next, this is kind of a clarification on the pay scale disclosure. So this is effective January 1st, 2026, and it basically amends the pay scale law, requiring that employees can actually now request at any time during employment whatever their pay scale is. So in other words, if they're, let's say, at, I don't know, at $85,000, you need to now tell them if they ask what the entire range is for their position. So it may range from 80 to 95, for example. So they need to now know that, okay, for their position. So whereas before it was if they were a job candidate, now that's expanded to say that, they can request this at any time during employment. And the pay scale must reflect a good faith estimate of the salary. And this is kind of a clarification on the original law because a lot of employers had questions about this. Well, what are we supposed to do to be compliant? It has to be a good faith estimate of the salary or the hourly wage for the employer. And this is all, supposed to be reasonable based on the position at the time of hire. And there are certain additional requirements for employers that are that have at least 15 or more employees. And these requirements include the pay scale must be in any job posting. This piece of it isn't new. But again, this is a reminder. And also if you're hiring a third party to announce or post for you, whatever your job posting is, then you have to absolutely provide that information to them. And that third party must include that information in the job posting. Next. I think this may be out of turn, but it is an elaboration on the prior one regarding the repayment of debts. But I already went over this, so we can skip. And you guys will receive a copy of these slides so you can have them for reference. Okay, so SB 642, it broadens the equal pay protections. It amends the Equal Pay Act, and it clarifies the term pay scale to basically mean the salary or hourly wage range that the employer reasonably expects to pay for the position up to hire. It extends the statute of limitations to 3 years for any claims pertaining to pay discrimination. And it allows employees to recover their wages. In other words, if they do prove that there was a pay inequity, as a measure of their damages, they can recover wages for up to 6 years in as part of their claims. Next slide. Okay, this one is SB 261, and it pertains to unpaid wage judgments. Okay, what this law basically says is that courts may impose a penalty up to 3 times the unpaid judgment that an employer has, plus interest if it's not satisfied within 180 days after your right to appeal has expired. And so employees, the labor commissioner, and the public prosecutors are automatically entitled to fees and costs in wage judgment enforcement actions, which we know could be pretty significant depending on how long they're trying to enforce. And public prosecutors can step in as assignees of employees to enforce those unpaid judgments. Next slide. And I have here that 50% of penalties to the affected employees are collected, and the other half goes to the DLEC for enforcement and education. So this is really significant, right? And business reorganizations or transfers cannot shield companies as successors. So, definitely take a look at this one and make sure that if you have any unpaid wage judgments, that those are paid And again, not surprising that California is trying to strengthen the employees' rights and ability to collect in any unpaid wages. This, I think, most often, like as a practical matter, would come up in labor commissioner hearings, for example, where an employee files a claim via, with the DIR and tries to collect for, failure to pay overtime, unpaid meal and rest break premiums, commissions, etc. These would all be unpaid wages, right? And let's say that sometimes what ends up happening is my clients either don't receive notice of this claim, or they end up actually receiving notice, but they don't take it seriously and they just ignore it. Or they don't ignore it, they proceed to a labor commission or conference. The claim doesn't settle. They go to the hearing and they end up getting this judgment against them. And then at the end of it, they want to dispute it, but at that point, it's too late. And, you end up having something like 10 to 15 days to appeal the judgment. And at that point, the judgment ends up being recorded by the court, LA Superior Court, and the plaintiff has the right to collect at that point, right? Once it's a recorded judgment, you really don't have that many recourses, right? So what this is saying is that at that point, if plaintiff and whoever else on behalf of plaintiff is trying to collect these judgments, there's now going to be costs and fees added on top of that. So be careful in ignoring labor commissioner claims, right? Okay, next slide.
Okay, before we move on, if you're going to put a question in the chat, please put what slide it pertains to. You can see at the bottom of the screen, or what Kristina is talking about, because we have 27 slides and we're not going to remember if you're not specific enough.
Yeah, you can reference the page number, and that way
Yes.
I can actually go back
Yeah.
to that slide when we're
Right.
talking about it.
Yeah, so the page number is at the bottom.
Yeah. So, how to protect yourself. I mean, this is pretty commonsensical. So make sure that you are aware of what outstanding judgments you may have. And if it's really tough or you really just want to dispute this thing, contact, counsel or someone to try to figure this out. Almost, 99% of the time you can settle these for something that's reasonable. If you show a inability to pay or some kind of a hardship, you'll probably be offered a repayment plan that makes sense for your pocket. Make sure that you strengthen your compliance programs because my position, prevention's the cure. So let's not have these wage judgments to begin with, right? Audit your wage and hour practices, train your managers to enforce them, make sure employees are taking meal breaks and receiving overtime, clocking in and out for meal breaks and when they come in and when they leave for the day. All of that, increasing vigilance really prevents these kinds of claims or stops them in their tracks if they are filed. Next slide. So there are our favorite statute, the PAGA, right? Private Attorney General Act, continues to be revised and clarified. There are increased penalties for violations with new caps on penalties based on compliance actions taken by employers. I will break down this mumbo jumbo for you. To be honest, the cure procedures and the early compliance opportunities are all BS because you can't really cure unpaid wages. You can't cure failure to pay overtime, failure to provide meal and rest breaks. You can't cure any of that, right? So the early cure procedures and the early, fixing of problems really only applies to very minimal violations or errors on the face of the pay stubs. And even then, those are very limited, right? There's only very few things that you could cure under this PAGA, reform. So really, at the end of the day, if you've got these issues, they do need to be remedied by settlement. And the settlement, like in all likelihood, is going to include some penalties, some level of penalties, but the unpaid wages, they cannot be cured early or late or whatever, right? They have to be settled. But as far as PAGA revisions go, I mean, the state is really just trying to make it more favorable to the employees while making it look like they're helping the employers, but they're not. I mean, call me cynical, but that's just really it. At the end of the day, they've expanded the amount of penalties that will go to the employees, which, believe it or not, I do like, because in the past, you had the 75% going to the state, 25% going to the employees. And in every settlement that's structured, plaintiff's counsel tries to give the absolute lowest amount to the employees and pocket, the majority of it for themselves. So this actually changes the landscape a bit and increases the penalties that are going to go to the individual employees. So that's good news in my book, as far as, relatively speaking, good news can go with PAGA. And I'm happy to go into more detail if anybody has more questions. We can move on to the next slide. This rehire obligation still lingers. It's very frustrating to a lot of clients, and it's been around since COVID-19, okay? And this has been amended just to extend the protections. Just keep in mind that they're around. They're not going away just yet. And this is applicable specifically to certain hospitality and service workers. And all you have to do is, if those people stay, laid off, then you have to offer them information about the available job postings and make offers based on qualifications and length of service. In the last 5 years, I have seen several lawsuits come out of this. And because of the hyper-technical requirements of this statute, like the way you have to comply with it is so hyper-technical. Like, you have to mail the notice and send it electronically. You have to do it within a certain number of, days. You have to, there's quite a bit of requirements, right? You have to look at the length of service of the people that you're offering it to, so that it's not, that it's not in violation of this labor code section. So at the end of the day, make sure you are complying if this applies to you. And we can move on to the next section, or the next slide. There we go. This is pertaining to paid family leave, and it goes into effect in 2 years. But something to keep in mind, that the PFL benefits are going to be expanded to include employees who take leave to care for a seriously ill designated person. And I have the definition here of who the designated person is. And eligible workers are going to receive up to 8 weeks of PFL wage replacement for this reason. And they'll have to, they'll have to apply subject to the EDD qualification and whatever the funding mechanisms are. Next slide. There is an extended statute of limitations under AB 250, and it pertains specifically to claims of sexual assault, like sexual battery and sexual harassment claims. I have a lawsuit like this now, and it is extremely burdensome because it goes back far, far, far back. Like something like 13 years, even though all the other claims still have the regular four-year statute. What this does, what AB 250 does, it creates a temporary revival window for these types of claims that would have otherwise been time barred. Okay. And so it's a very egregious revival, and obviously it's intended to help the victims and the survivors, but it does make it very burdensome. As a practical matter, what this means is litigation could really go back as far back as like 13 years in discovery, looking at the documents and the records and the evidence to, to be able to defend yourself in such a claim. Okay, next slide. SB 809, this goes into effect January 1st of this year, and it clarifies that owning a vehicle doesn't make you an independent contractor. In order to look at this, really examine it, the ABC test still applies. So it's really going to be, how much control does the employer have over the worker? Is the worker performing work within the scope of your job duties? The three-pronged test. This particular legislation, it reiterates that employers must reimburse employees for using personal vehicles for work, which means any and all expenses related to the mandatory use of personal vehicle, including maintenance and gas and things like that. And it actually creates a limited amnesty program for any workers that are misclassified construction trucking employees if that person signed a settlement agreement with the labor commissioner. And there's a deadline here, and there's very specific terms that settlement agreement has to have in order for this amnesty program to apply. Next slide. Okay, SB 464, this is employer data reporting, and it increases the number of job categories from 10 to 23 that are required in employer paid data reports. And this one is starting 2027. It requires, storage and separate storage and demographic data to be retained. It creates a civil penalty for employers who, fail to submit these reports to the CRD. We've dealt with this, on some level with other employer reporting. So I know this one isn't going to be burdensome or new. You just really have to understand what it is that's required. And, as you may already know, this one applies to bigger employers with 100 and more employees. Next slide. Okay, this one is an important one. This is SB 294, and it requires a notice, and this notice has to be annual, standalone, and it goes, you need to know 2 dates for this one. February 1st is the date by which you need to inform employees, in other words, provide this notice of their rights, including immigration and law enforcement. And we know employees are very ambivalent about this right around now. And the second date that's important is you must designate an emergency contact for each employee no later than March 30th, 2026. And the notification requirements is one thing. The other requirement is that the employer has to notify the employee's emergency contact if an employee is arrested or detained while at work. So you need to give this notice to employees, informing them of their rights surrounding immigration and law enforcement. You need to make sure they're designating an emergency contact by no later than March 30th. And then if they are arrested or detained while at work, you need to notify that emergency contact. Okay, next slide.
Really quick again, if you're putting questions in the chat, please make sure you put the slide number or the topic so we're able to answer the questions easily at the end.
Okay, that I think answers the question that just came in. Yes, there is a template notice, and it's actually required that you use it. So the labor commissioner just provided it. I can provide, I know you can't click on the hyperlinks here, but there is a template notice the labor commissioner puts up already posted. It's in English and Spanish. And you should be using that notice. And notably, not only is it required that you do it annually, you also have to do it to every new employee at the time of hire so that they have it. And there's penalties for non-compliance up to $500 per employee. Next slide. Okay, there is also an enhanced Cal WARN notice requirements, and it went into effect January 1st, 2026. And, you guys probably know, WARN Act, Cal WARN applies to layoffs, relocations, and closures if you have mass layoffs. This requires, it expands required content for the notices. Next slide. The next slide. Okay. And there's now a requirement that the employer explain or state whether they will coordinate services with the local workforce development board. And again, this, as you can tell, this is really trying to expand the support offered to employees who are being laid off. And so the employer now needs to make sure they disclose to the employee whether they're going to coordinate any services with the local workforce development board, whether they'll use alternative service providers or whether they have no plans for coordination so that the employee knows exactly what to expect. And again, this is another one where the legislation requires that you use mandatory language. So it's almost like they're saying, yeah, we are increasing protections to employees and we don't really trust you, employer. We don't trust you to give them the notice that, of all these things. You need to use our own language, right? So there's very specific language that the notices must include. If you look up SB 617, it actually has the specific language that you have to include. And you also have to include the contact information for the local board if you're, coordinating, and make sure that you do conform to the mandatory language, because if you don't, then your notice arguably isn't going to be compliant under SB 617. Next slide.
I'm going to just jump in here really quick because
Yeah.
I sit on the local workforce development board.
Mhm.
And recently, one of our members, which is the Airtel Plaza Hotel, they closed,
Mhm.
and they fell under the mini WARN Act before this SB 617. And, sorry, and I connected them with the people at EWDD, Economic Workforce Development Department, who work with the Workforce Development Board, and they have a rapid response team. So if you ever need this, they brought I didn't even know these organizations existed. Everything from EDD, and we have business source centers and work source centers. Everyone came in. They actually sat down with every single employee and found out all different things, like if they're eligible to go back to school that would be paid for. It was an amazing experience. So even though this sounds really scary, these things, when the Workforce Development Board steps in with rapid response, is the best thing that could ever happen to you and your employees.
Oh yeah, they're no joke. They really do have very expanded support.
Yeah, and then in the chamber, they use the work source centers in the city of LA. The work source centers, and if you're not in the city of LA, they would be an AJCC. They're all members of our chamber too. So we can go to them, but then we miss all the other departments, and that's why we go to EWGD.
Mm-hmm. Okay, thanks for that, Nancy. I think that's really cool that you have this information. Okay, so the other requirement is the CalFresh disclosure. You need to notify the affected employees about CalFresh, what it provides, like what, benefits it provides, like food assistance during unemployment. And, if the employer does elect, the coordination, then it has to be arranged within 30 days. And like Nancy said, like you'll definitely get, a lot of support there. Your employees will. Um, and employer, you can't just state that you'll do it. At some point, you actually need to follow through quickly to be able to be compliant under the statute.
But if you bring in rapid response, they'll bring in all these departments. You don't have to do anything.
Oh yeah,
Like
that's
they take
great.
care of it for you.
That's really great. Okay, next slide. Okay, with SB 513, there is an important personnel records update. The requirement for what records need to be made available is actually expanded. So definitely take a look at this. There's an expanded definition of personnel records, which now includes training details, for the employees. So including, certifications, what skills they've worked on, and who the provider was and how long the program lasted. And I have the details listed here. So the name of the employee who received the training or whatever the program was, the training provider, how long they trained, and the core competencies of the training, including skills and equipment or software, and whatever the certification or the qualification they received. And to tie this back to that, you know, contracted repayment option, if this certification is a prerequisite to performing their job duties, you can no longer force them to repay this to you if they don't stay with you for at least whatever 6 months or a year. Just a quick reminder. Next slide. This is a transportation network company drivers labor relations act. Very long name. And effective January 1st, it establishes the collective bargaining rights for gig drivers. I mean, wow, like this thing sets a brand new precedent, right? What the law basically says is with rideshare drivers, with app-based delivery drivers, these people can continue to stay as independent contractors, but they can now organize. Okay, they can form labor organizations, engage in, collective bargaining. They can basically do what your employees do, right? So how crazy is this, Nancy? Like I can't even. I didn't realize that it would get this bad. Next
California.
slide. Crazy, right? Um, Next slide. This one is very serious, especially for companies where you have tips, restaurants and anywhere else similar to that basically offer tips. This was signed in middle of last year, and it authorizes the labor commissioner to investigate and issue citations to for tips that are taken or withheld in violation of the labor code. It adds a private right of action to employees to just basically, sue directly for violations of California gratuity laws. And again, it's very serious. Next slide. The penalties are between $250 dollars per violation that isn't willful, oh, it was an honest mistake, and $1,000 is the cap for willful violations. In other words, what ends up being willful automatically is if you're doing it despite having been cited in the past, if you're doing it literally to every single employee and it's happening across the board over a span of time. They will treat that as a willful violation, and will be very expensive. Um, the This law also reaffirms that tips are the sole property of the employees, and so I mean we know that. but this really clarifies that and treats this as like a much higher bar now for compliance, and expanding enforcement, because now employees can, individually or on behalf of others, be able to bring this type of action under tip theft. Next slide. This is AB 288, and starting January 26, the California Public Employment Relations Board will be authorized to decide unfair labor practice cases and order the appropriate relief, including penalties, when a worker brings this type of charge and they are employed in a position that's covered by the NLRA, and loses coverage under the NLRA because of a repeal or redefinition of certain certain laws. Next slide.
What's NLRA?
It's the National Labor Relations Association. Excuse me. That's it for the list. I know it was kind of jam-packed. I'm happy to take any questions now. Whew, there's quite a bit.
I know. Don't worry, I'll go over them.
Okay.
Hold on, 'cause I gotta go to the top. Well, for people who came on late, yes, the slides will be shared. If it's a pinned post, it says the slides will be available tomorrow. The recording will be available next week because we have to edit out all the conversation at the very beginning. So let's start. I gotta find it. Oh, and if you we put the link in for the labor law posters too, and the link for SB 294 in English and Spanish. So you will have to like scroll through this. You can save the chat and find all this later. Okay, now this one doesn't have a slide number, but for large, but this is at the beginning from Jennifer Bravo. For large employers with employees in multiple markets, do we have to provide the salary for each market?
Markets. I would say absolutely, because the requirement is that you provide something in good faith that that reflects the position and essentially covers the range. And each market is going to have very different pay scale based on the reality of that market. And it does so, and it does apply to large employers. It applies to employers with 15 plus employees. The requirement was just clarified that it needs to be good faith pay scale, right? And so because each market is going to be different with, its own different market reality, the answer is absolutely yes.
Okay, great. Then if someone pays, they have seasonal employees and they pay them one rate, no range. How does that work? How
Well,
does that work?
then that's it. Then that's
Okay.
it. I mean, you don't have to provide a range if there isn't any.
Okay. And then on SB 261, do you have to make any payments during an appeal?
Um, any payments during an appeal. Are you referring to the
Well,
judgment?
Russell, you want to unmute and ask that question?
Yes, if you've gotten a judgment against you, but you appeal it,
Mhm.
does the clock start for the
Yeah,
penalty?
yeah. No, hey Russell, thanks for clarifying. No, the appeal, if the appeal has been properly perfected, then the judgment is stayed. Under SB 261, those penalties are triggered only if a final wage judgment remains unpaid after the appeal period has ended. So at that point, you have no appeal rights. So yeah.
Thank you.
You got
Okay,
it.
I put up slide number 11 because we have a few questions on it. Do we need to have a written record of rest breaks taken by non-exempt employees?
No, California law doesn't require that you track rest breaks.
Okay, and then I think this is a similar question. What about an exempt employee that was on salary requesting they weren't paid for?
Requesting that what? That they weren't
They
paid?
weren't paid for. So I'm assuming Tracy, I'm assuming you're saying the exempt employee is saying they weren't paid for their rest breaks. You
Oh,
could have,
like claiming misclassification kind of a thing?
no. Tracy, Bo, do you want to unmute and clarify? Oh, she's still here. She says this is why overtime. This is why they are salary, but they claim it was too much overtime. I don't understand.
No, I think I understand the gist of the question. It's basically like a misclassification allegation. Because when you're salaried exempt, like a true salaried exempt employee, assuming they fulfill the duties test, in other words, they can properly be salaried exempt, and they are paid at least the minimum salary that, for that year, which is 2 times the minimum wage, and they're truly salaried, then there is no such thing as too much overtime. They can literally work 24/7. I mean, not that I'm suggesting they do, and still be salaried employees who are not warranted any overtime. So there is no such thing as too much overtime. You aren't required to track the hours for a truly exempt employee. In fact, tracking them would make it seem like you are misclassifying them because you're not supposed to be tracking their hours if they're salaried exempt, and you're certainly not required to track their meal or rest break periods if they're truly exempt.
Thank you. That you got my question answered. Thank you.
Okay, you got it.
Okay, slide 12. How far back can we go to fix missing info on a pay stub?
How far back? You only can go far back as they can recover for that claim. So, for example, if they're claiming, missing certain things on the pay stub, um, failure to, for example, provide paid sick leave tracking, or just a missing pay stub altogether for whatever reason, like there was maybe like a glitch in the payroll process or whatnot, then you could really only go back like 4 years because that's as far back as they can recover if they file a lawsuit. And typically, if it's unfiled, they go back 3 years. So hopefully that answers your question.
Okay, then what is the statute of limitations for rehire?
For rehire? I'm not sure what the question is.
Deborah Pfeiffer, you want to clarify that? You can unmute.
Yes, I was just curious if you have somebody that has been laid off,
Mhm.
is there a statute of limitations as to how long you have to provide them additional opportunities?
I see what you're saying. I mean, there's no expressly stated statute of limitations in the rehire statutes themselves, but practically what it would mean is like a measure of their damages. So let's say they claim, failure to rehire, lost wages, right? Which is what they would be claiming. They would be claiming like, oh, I was damaged in the amount of back wages I didn't receive that I should have received had I been hired, right? Those go back 3 years, like I said earlier. Like everything relating to wage and hour violations typically goes back 3 years. But if the case is filed with with the court, then that statute typically expands. There's an additional claim that's pled in almost every single case that's filed. That expands the statute of limitations to 4 years.
Excellent, thank you.
Okay, you're welcome.
Okay. I love this next question. The designated person, because it's for paid family leave, is it one person for the year, or can it be multiple designated people based on each instance? You understand what that means, right? Like you could have a designated person and you take off up to 8 weeks for them, and then you could have another designated person. How does that work?
Mm-hmm. It's a fair question. Yes, over time, an employee may designate different people, but based on the statute, you only have one designated person per that PFL claim or whatever that leave event is. So hopefully that answers it.
Okay, and then how do you dispute a claim by the employee of the designated person?
How do you dispute a claim by the employee? I'm not sure what that means.
Yeah, Marta.
Yeah, if you suspect that there's fraud in the claim of an individual.
I see what you're saying. Okay. Yeah, I mean, disputing it, meaning like, how do you challenge that request, right?
Yes, yes.
Um, I mean, the paid family leave is administered by the EDD. And so only the EDD determines eligibility. Okay, so I think there may be a misunderstanding. The employee certifies who that designated person is, and they make those representations to the EDD, and then the EDD evaluates and either approves or denies that claim. So the employer doesn't verify the relationship, and in fact, my recommendation is that you never ever demand the proof. If an employer tries to investigate the relationship and make sure there's no fraud, that actually creates interference, and it subjects you to retaliation risk.
Okay, thank you.
Okay, you're
I'm
welcome.
gonna jump into because provide a grant for businesses for employees on paid family leave. So the employee or the employee would be the one filing the claim, like Kristina said, and then you click the box of what eligible category, whether it's because of a military occurrence, your baby bonding, whatever it is, and then sometimes you have to provide proof from your doctor depending on what for what you're doing. Sometimes you don't. It all depends on the claim, and then EDD will verify it, and they'll send you, the employer, the documentation. I forgot what the form number is, but regardless, and that's the what do you want to say, the trigger that they qualified for paid family leave, and that they get 8 weeks off, and then they get paid that from wage reimbursement through EDD, not from you.
Right. Exactly. Yeah. So this isn't something you're going to pay for.
Okay, how can we get confirmation from the employee that the designated person in fact falls within the category? Well, we just answered that. That's EDD's
Yeah.
determination.
Not your job.
Yeah. Yeah, I mean, it'd be nice, right? But you can't. And let's see, slide 16. Does paying mileage cover an employer for SB 809?
No, it doesn't, because it typically includes every expense that's, reasonably expended because of, this mandatory use of your personal vehicle. So mileage reimbursement by itself isn't like a safe thing. You need to fully reimburse the employee for all the necessary business expenses. And mileage obviously is just one component of that obligation, but it's going to include everything beginning with fuel, wear and tear, maintenance, the insurance for the vehicle, and that so that definitely needs to be expanded, not just mileage.
And then do you need to reimburse an independent contractor for their car and mileage?
Well, under this new requirement, apparently you do.
Wow.
Yeah, and I know. I mean, a lot of it is still really to be determined. But I mean, look, generally under California law, you're not really required to. Okay. But with the big caveat here with misclassification risks, um, more often than not, the driver shouldn't be an independent contractor. Okay, more often than not, with the exception, with some exceptions, um, with true independent contractors, if they're properly classified, then the reimbursement typically is going to be governed by the independent contractor agreement that you have with that contractor. That you can, many of these types of agreements, they build expenses into that rate. or they clearly state that the contractor bears their own costs. But just I caution you with respect to independent contractors, definitely contact me or someone else who can help you assess that you're properly classifying them.
Okay, slide 18. Is there a sample form for the emergency contact, or is it sufficient to use current emergency cards, or does it have to be a separate one that's specific
No,
for SB 24?
current emergency card is fine.
And then it says, is there a template for the written notice? It's been put in the chat a couple times. I know Jennifer answered it to Marta, but we added both the English and Spanish one that Kristina had linked. Is there a flyer for the immigration law like template? Is that what we're just same thing that we're talking about, the notice?
Yeah, that is. Mhm.
Okay, so slide 18, do you just email the employee to provide you their emergency contact? If they don't respond with the contact, are you exempt?
No, you're not exempt. In fact, if you don't get it, if you don't, if you fail to obtain it, I mean, there should be no reason why you fail to obtain the emergency contact. Obviously, if you have a good document trail that shows, well, we reached out, the employee specifically stated, and you have a copy of that statement in writing that says, I do not wish to give you my contact, whatever emergency contact, or I don't have one, or it's none of your business, right? If you have that in writing, then perhaps you could show that, right? In the event something like this happens, they're detained or whatnot, and you fail to, notify someone. But you shouldn't assume that you're exempt, right? You can still be on the hook, but you'll have this written evidence as defense.
Okay. Okay, on SB 294 and slide 19, which I have up, if someone's arrested at work, does that include while working remotely or in field work?
Yeah, absolutely.
Okay, going back to, sorry, I must have scrolled and didn't know it. I'm going the wrong way. Sorry, folks. On slide 18 again. Just trying to follow the questions. Slide 18, we just need to give out the flyers or the template. No need for a signature of a receipt.
I would, I mean, it's a really good question. I guess if you could get signature and receipt, that would be good. But as long as you're sending it out, depending on how you typically provide employees notice, and there's proof of that, you should be fine. I mean, some clients send it via email, so then you have a copy of this email that went out, and but I think you really do protect yourself if you obtain a signature, because it's one thing to say it went out, it's another thing to say, I know it was received, right?
Right.
So definitely you protect yourself better if you get the signatures.
Okay, and then on a WARN notice, is there one that's available for download? And I'm just going to say really carefully, there's different WARN notices depending on the size of your business too. So,
That's absolutely right. There is no one size fits all WARN notice. It's all going to be different. And so it's based on the size, the type of event, and so that's the answer. There's no one template.
it's like in California, we have mini WARN notices, like I mentioned, which are for smaller employers and they have different thresholds. But are there templates though, if they needed that?
No, I mean, it's something I could put together, but there's no official, California WARN or even a mini WARN template that's issued by the state. Now, I can obviously give you something, but there isn't like a state issued or agency approved template.
Well, and I'm thinking the Workforce Development Board or the America's Job Center, if you're not in the city of LA, can also probably help you with that.
Yeah. I mean, there's lots of places where you can, yeah, but look, the WARN notices have to include all the statutorily required information, right?
And then
And the key is
on
which,
EDD's website, it's just, it lists all that, what you have to include.
Right. And what Nancy was also saying is that it really depends on which WARN Act applies to you. You're either under the federal WARN Act or you're under the, the California WARN, mini WARN. Like, so the notice has to contain the specific disclosures pertaining to that, right? But you don't really need to do like a verbatim anything. It can really vary.
Right. And they apply for mass layoffs most of the time, not just because you laid off a few people. It's a
Right.
trigger.
Mass layoffs, closures typically is what warrants it.
Okay, so for SB 294, do we need to post annually even though the new hire will receive the notice with their new hire paperwork?
No, I mean if so you do need to post annually and with the newly hired individual.
Okay.
Okay.
Well,
There's two requirements.
okay. And then we've put the links for English and Spanish for the Know Your Rights. And if you scroll through, it's at 10:39 a.m. Okay, for SB 513, is there a look back period for updating the information provided on training certificates that are already filed in the employee personnel records?
No, I mean it just goes into effect, beginning the effective date. You're not really, it doesn't create a special look back period of its own. But again, like I kind of, law is not very intuitive with respect to these things in that you always have to look at what are the damages, right? And the damages are what the employee would collect or try to receive by way of compensation if they filed a claim. And again, the statute of limitations on these claims, what they can practically go back and collect for is 3 years, right? So the 3 year look back, and in some cases it's going to be the 4 year look back, depending on the underlying statute that's being enforced. Um, so, so hopefully that helps you, but there is no need for you to go and try to correct these things retroactively is my point, right? So just use that.
Okay, so slide 26, how does SB 648 work with pooled tips in a restaurant?
It doesn't matter whether they're pooled or they're individual, it doesn't matter. What does matter though is that if you have a pool that you have properly and clearly, defined how the pool works, and fairly allocated and distributed the pooled tips, that you don't pocket the pool tips, that you don't allow managers who don't perform the same duties as other employees in the pool tips are taking those, right? Because managers, supervisors, owners aren't supposed to claim part of the pool tips or any tips unless they, 90% of the time they're performing the same job duties as the employees in the pool. So those are the types of things they look at. Okay. Is there more questions, Nancy?
Sorry, you didn't hear me. Okay, there's another, sorry, it was on mute while I was coughing.
Oh, okay.
Okay. At which point, I think this is the same question. At which point, if the employer is withholding tips, if it operates pool tips and pays everyone at the end of the week for all tips collected? I think what you just answered is that same question,
No,
correct?
I think this is more specific. This is just that is lawful under California law. You're required to pay out the tips by the end of the pay period. So if you're paying them by the end of the week, whether that's the definition of your pay period, like some employers pay weekly, right? Others pay bi-weekly, others pay semi-monthly. Whatever that definition is for you of what the pay period is, you must pay out your tips by the end of the pay period, including cash tips and credit card tips.
Okay, SB 13, how should employers handle training and education records for union employees when the unions control and store the detailed training documentation and collective bargaining agreements do not address sharing or maintaining individual training records? Should we be concerned?
Individual training records, I'm not really exactly understanding the problem. So you're saying that you're concerned that you don't have access to the training records for the employee
So,
because
Amber,
they're stored
uh,
with the
and
union?
Amber, hold on. You could unmute, but I'm understanding this is there are certain things under DAS, the Department of Apprenticeship Standards, and the DOL, where unions can require, like in their union bargaining agreement, what training the employees need to take, and then they control some of those records. I think that's what Amber's saying, right, Amber? Yes. Yeah. So what she's saying is that you don't always have access to these ones that are kind of regulated under DOL. It's really weird, Christina. I only know it because of the employer, how we have that job training contract.
Mm-hmm.
So you don't have access to them. So how does that apply to SB 513? They're not training you're providing, right, Amber? I think the unions also do some sort of training. So where does that detailed training fall in? Because they're not provided by the employer, they're provided by the union.
Mm-hmm. I mean, yes, I mean, even if a union controls the training or, keeps those records, the employer remains legally responsible for being able to prove compliance with with the mandatory training laws. So, with SB 513, you need to be able to produce those records if the requirement comes in. And they're not gonna, they're not just going to allow you to say, well, the union has the records or the training was, provided through whatever the CBA. Um, you can require, you can include language in your CBA agreements that requires the union or joint, training trust to provide those training records. And now that this went into effect, there shouldn't be any problem, for you to reach out to them and say that we really need to iron out this provision because we're going to be on the hook whether you have those records or not, whether we have them or not. We need to be able to have access to those records and obtain the duplicate records to maintain in the personnel files.
So just so you know, this is a union sponsored bill. And so the unions are always concerned that employers are not investing in upskilling their workers, especially in technical fields. And that's why they made this whole thing to make training documentation a legal requirement. So I would think they would have to give that to you, Amber. And
Yeah.
I'm happy to ask someone at the Department of Labor and find out for you.
Yeah, absolutely. And with this requirement, all you have to do is basically say, look, we're required under the law to maintain and provide this upon request. We need to have this in our agreement. I mean, but like Nancy said, I really don't think this is going to be a problem.
Yeah, but that makes it sound so easy. I just had a meeting with a union, one of our members, about training, and they required them to do so much training. We were providing money for it, and they were like, "No, we don't want that." I'm like, but we're helping them pay for this training you're required." So it's like it's not as cut and dry as we think
No,
it
it's
is.
not as cut and dry. I agree.
Yeah,
It's probably
yeah,
going to require like 10 different phone calls
yeah,
and meetings.
yeah.
But yeah, I do recommend that you make the effort.
Okay, so let's move on to the next question because there's a lot. What is the process for former employees who are ineligible for rehire due to policy misconduct or attendance issues?
Yeah, I mean, that goes to their eligibility, right? So if you're not required to rehire someone who was terminated for performance, you are only required to rehire someone who was terminated, who was laid off as a result of the pandemic.
Okay. SB 513 training records. if an EE manages their own certification, continuing education units for a particular certification, do we have to go and ask them for records such as date, duration of training? We have not typically kept this info on record. And
Similar to the deal, similar to the, like what we just discussed. Yes,
yeah.
you do. Yeah.
And let's see, does this apply to internal training that does not result in officially recognized certification or qualification other than internally within the company?
I mean, it's a really good question. The requirement is kind of broad, but I would just err on the side that it does. It depends, right? I mean, if you're really just training the employee how to do their job and it doesn't result in any certification or any of that, I would think it, I would think you wouldn't have to, but when in doubt, create the record and put it in their file. I mean, I always urge clients to always document any training efforts because of how frequently we face failure to train and discrimination claims, right? Because oftentimes you'll fire someone and they'll say, well, you fired me for not being able to perform my job, but you failed to train me, right? You failed to you set me up for to fail, right? Because I, had a medical disability or because blah blah blah. So my recommendation is always document training in the file. Because it just, as a practical matter, protects you in the event of a lawsuit, and it fulfills this obligation should it be applicable to that type of trading.
And like, depending what type of business you are, if you do any ETP, employer training panel training, whether it's through a multiple employer contractor like us or on your own, your training coordinator, like if they're an outside person, has all those training records. Like we have to keep them. So you could always get copies
Mhm.
from them too.
Yeah.
So Tracy McLeod, what if a person only takes 1 day a week? I don't know what slide or question that has to do with. Can you elaborate? I don't know if she's still here. Okay, well, when she comes back. Okay, so for PFL claims, is this protected if not qualified under other leave types?
For PFL claims, what's protected?
Is PFL protected if not qualified under other leave types? Jennifer, are you still
Um,
here?
I'm still here. Yeah, my question is specifically under this new PFL provision,
uh-huh.
are there job protections associated to being a designated person and taking the 8 weeks if this, because normally the
I got
PFL isn't typically protected.
Yeah, no, I got it. No, no, that isn't gonna alter that. If employees receiving PFL benefits, um, the leave itself is not protected unless, unless other type of protection applies like CFRA or FMLA.
Okay, and then just really quick, because we have a few that have to do with FMLA,
Mm-hmm.
and I'm going to just use it. I'm going to do them to kind of like together,
Okay.
because we're not talking about FMLA today, and that's different than paid family leave because it also has to do with employer size. But
Mm-hmm.
are there exceptions to provide 12 weeks of FMLA leave for an employee that is taking care of a chronically ill parent that lives outside of the country?
Other exceptions to FMLA leave. Sorry, for
Are there
what?
any exceptions to provide them 12 weeks if their chronically ill parent lives outside the country?
No, no, there aren't.
Okay. If an employee that needs to take FMLA but only wants to take 1 day a week, oh, here she clarified it, for
Oh,
her
okay.
8 weeks coverage, can she do that?
Yeah, absolutely. You can take FMLA leave intermittently, 1 day a week or even, 4 hours a day or whatnot. But yes,
And that's same for PFL, just so everyone knows.
yes.
Um, if an employee is involved in a fender bender and their car is damaged, will the employer be responsible to pay for the damages?
Well, the answer is it depends. Was it during during the course and scope of their employment, performing their job duties? Then arguably yes.
Okay, we utilize group text messaging for staff communications. At times, employees who are not scheduled to work may receive or respond to these messages. May this time be counted as compensationable?
Yes,
Time to,
compensable.
yeah,
Yes,
do the group. Yes.
absolutely. Every time that you're communicating with the employee, um, about their job, right? It's not like, hey, you want to go out to dinner, like that's different. But if it's something about scheduling and obligations, it's all compensable. And if you're also um, requiring them to respond to you using their cell phone, you're also required to reimburse them for the use of their personal cell phone.
Yeah, and
Christina,
then
can you repeat that first part of that, please? We
Yes.
group chat.
Anytime the employee is under your control and direction. So let's say you're texting them, you're calling them about the job, right? About
Mhm.
shifts, scheduling or anything else, coverage. That's all compensable time.
Okay. So how do you recommend that we would communicate to like an entire group? Like I have nurses, so if I want all the nurses to know, the shifts available, can anybody take it type thing?
Mm-hmm.
Or if we want to post something that's maybe procedural that is new and everybody's not aware of it or they're not complying with it. So
Mm-hmm.
we post things like this on a HIPAA compliant site.
Yeah, I mean, so when they receive those messages, when they review those messages, the time spent reviewing those messages is compensable because you're communicating a message regarding their work, right?
Mhm.
So, I mean, the question is, are you asking how do you do it so that it doesn't end up being compensable time?
I think so.
Okay. Well, I
I
mean, the obvious solution would be to just post it during their work hours. And, but then if everybody has different shifts, you're never going to get
Yeah,
everybody, right?
right.
So at the end of the day, I wouldn't worry about it. I mean, you're really talking about a few minutes worth of time. And
Yeah.
what is important, though, is to condition employees to record every minute on their time sheet, assuming they're hourly employees. To track every single minute of hours worked, including things like this, right? So you need to train the employees, train their managers, make sure the managers are explaining to employees everything beginning with phone calls and time spent reviewing documents and communicating to us is compensable time.
so we have 8 minutes left and we have 15 more questions.
Okay.
So if you want, anyone wants to email me, I could connect you with Christine if it's more detailed like this, please just email Nancy at sanfernandovalleychamber.com. Nikki or Emily could put my email in the chat.
Or you
Okay,
can email me directly. My email address is in the slides too.
that's true. But we're not going to send the slides out right away. That's the thing.
Okay, so you can
But
put my email
yeah,
address in the
okay.
slides too.
Okay. Would SB 809 also include exempt company employees when use their own personal vehicle as part of their job?
Would SB 809 include what kind of employees?
Exempt,
Oh,
exempt.
exempt employees.
Hmm.
Um, Hold on, let's go back to that
I don't,
slide because
I don't know. Well, I don't know what slide number it is. That's the problem.
okay, that's fine. So if we're talking about expense reimbursement obligations, which I think is where you're going with this, then the answer is yes. Whether it's hourly or exempt, you are required to
Here it is.
reimburse. Um, you are required to reimburse employees under Labor Code 2802.
Okay.
I guess my question had to do with if an exempt employee is required to travel with their own car and visit locations.
If they're required to travel, what's the question?
If the employee is required to travel, that's part of their job, that they are
Uh-huh.
required to travel, use their own car.
Uh-huh.
And yes, they are paid mileage. but not necessarily anything that has to do with maintenance or anything like that. But they're required to travel to different locations that they need to visit.
Mm-hmm. Yes, then that's part of their job duty. Yes. You are required to reimburse them for using their personal vehicle. And as we discussed earlier, it's not just for mileage, it's for everything else, wear and tear, maintenance, gas, insurance, all of that.
Okay, thank you.
You're
Okay,
welcome.
still slide 16. Is there a legally acceptable method or standard to ensure a flat vehicle allowance complies with reimbursement requirements?
Yes. There
Okay.
is, and it's called a flat sum agreement, and it needs to reasonably compensate the employees for the expense. And I do it in a way that puts the burden on them to tell you whether it doesn't. So I do have an agreement if you want to reach out to me.
And also people keep asking, is this PowerPoint going to be shared? As I mentioned earlier, it will be shared and it's a pin post in here. So yes, you will get a copy of it. Someone as employed, we already answered that one. Information be on the know your rights. Should it be both emailed and posted, or is posting alone adequate for compliance?
As someone brought up earlier, it, it 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 would be perfect if you require that they sign it once they receive. So the concern with just email would be, well, did they ever receive it, right? So when you email, I would also have them sign so that you know for sure they received it. I would distribute it I would distribute it in a way, in a reliable way that you normally distribute important information to employees.
Okay. This really isn't a question, Hugo. If workers are required to pay for all vehicle-related expenses, delivery companies would not be able to operate sustainably. Additionally, there's no clear tracking or transparency to determine whether those expenses come from work-related use or personal use. Kristina, you got an answer for that one?
Yeah, I mean, this really isn't really true because there is an absolute clear way for you to track whether it's personal or not, right? And that is you need to figure out, well, if the expense was incurred during, off hours, for example, or you need to have them provide a receipt, and an explanation of what it is. And really, you're not required to reimburse any expense. It's a reasonable expense, right? So if the employee goes and stays at a hotel or drives, hundreds of miles to go visit their aunt, that's not on you, right? The expense must be actual and reasonable. And so you need to figure out a system where you're tracking what's reasonable and what the expenses really are, right?
Well, and I think it goes back to those old-fashioned days when you actually had a little mileage booklet and you would say, I went from here to here, and this is where I went. And then you have some sort of formula to figure out what your other expenses are based on whatever
Right.
percentage is. I don't think
And now there's also like now all the bells and whistles of GPS and tracking. So if they went outside the perimeter where they're supposed to be delivering or performing services, then that's arguably not on you unless they have some very good explanation for it.
Okay, we got a couple more on tips. If
Okay.
tips are pulled, is there a conflict that the language of sole property of employees for whom they are left?
Sole proper, no, 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 no. If there's a tip pool policy, I'll tell you what happens in theory and what happens in practice, okay? So in practice, all of my clients have those employees who are gonna pocket that tip, okay? And nobody will ever know. Because it was left for them and they took it, right? That never ever gets discussed. Nobody will ever know. Unless you like actually saw it in person and then tracked it to their pocket, right? But otherwise, when you have a implemented tip pool policy, every tip should go to to the tip pool.
Okay. What happens when a company requires 18% tips on cash payments, even when the client did not tip that amount or tip less? Is it legal for the company to deduct money from your credit card tips to cover tips that cash clients did not give, effectively making you pay the difference?
So this is kind of a loaded question. So 18% tips on cash payments. I mean, generally, it's not legal to deduct money from tips. And that includes automatic gratuity. There are very narrow circumstances, but typically under Labor Code Section 351, deductions are not allowed. Like the tips belong entirely to the employees, right?
Right. Okay. How do we determine how much to reimburse an employee for cell phone use?
It really depends. It's not a black and white rule. I talk to the employers and walk them through this. I ask them, well, on average, about how many hours, let's say, per week do they use their cell phones? If it's something like, maybe 30 minutes, I don't know, maybe 30 minutes in 2 weeks or like per pay period, then that's going to be a really low reimbursement rate, like, I don't know, like $5 or something, per month or per pay period. It really does depend on the amount of usage and if you're requiring them to use the cell phone.
Okay, so how do you you're talking to an employee after hours, like we were talking about texting. How do you compensate them? Is it like is it for each minute that they took to answer? Like how do you figure out what that rate of pay is?
Yeah, right, right. Well, again, it goes back to your time tracking policy, right? If you're talking to the employee after hours, it really after hour communications is absolutely compensable time. If it's not, unless it's like totally voluntary, right? Like, oh, I call on these 10 people, and if they pick up, they pick up. If they don't, they don't, right? If they're required to pick up, then it's, you basically need to figure out how long they were on this call. They need to absolutely monitor phone calls, reviewing messages, responding to text messages, and add that to their time, to their time sheet if they're an hourly employee. Okay. And that goes to your time tracking policy, right? That needs to be in your employee handbook, makes very clear that every single minute is compensable, should be recorded on your timesheet, and off the clock work is not permitted and will be, employees will be disciplined for working off the clock. And they'll get it, believe me. If you discipline for failing to record time worked, it's the best thing for you, and employees will get it.
Going back to misclassification, is there any feedback on an exempt employee that's also paid overtime when hours exceed 8 hours per day or for special projects based on completing a paper time card, which documents the overtime hours and approved as management decides it should be paid? Overtime is approved regularly and not often denied for the clarification, but
this is a very confusing but very bad idea. So the question asked about misclassification, but then said exempt employee who is receiving overtime payment. So this kind of merges three different things in here: misclassification,
Man,
exempt versus
we are going out
non-exempt.
of business.
What's that?
We have to pay for all the expenses to employees.
Okay, so
I didn't catch that.
Let's answer this question, and because we have a few more, and we want to get everyone out of here, and we only have a few more questions. And
Okay.
How about, Kristina, I'll send you the question, and we could email it to the person who asked it.
Sure.
Okay. If a communication is sent via like an app that's being accessed via personal cell phones, it still falls under the same compensable thing, right?
Yep, it does, yes. And so not just the reviewing of the message, but also the use of the phone. If it's required to be accessed via a phone app, then you need to also compensate the employee for accessing their app on their phone, right? You need to be reimburse them for that.
Does the IRS standard mileage reimbursement cover fuel, maintenance, and insurance?
No, it just covers mileage.
If someone already pays their employees for cell phone usage, can they also pay monthly for compensable notifications?
Sorry, can you repeat that one more time?
They're already paying their employees for cell phone usage.
Yeah.
Can they also pay them for compensable notifications?
They must, yeah, because compensable time involves reviewing messages and being on the phone, right? That's compensable time. That's separate for reimbursing employees for the use of their phone, right? So you need to do both.
Christina, I think what I was asking is per your advice, we pay our employees for usage of their phone based on, you know, who they are and how much time we need from them. Can we also just pay them on their paychecks for that compensable notification? So they got a flat fee coming, whether they have to respond or not?
No, you can't because you need to track, you need to pay based on actual hours worked, not a flat rate. That is not something you can pay as a flat fee. That needs to be based on actual hours worked, based on how much time they recorded on their timesheet that was spent reviewing notifications.
Okay, thank you.
Okay. Are exempt employees able to receive mileage?
They must, yes.
Okay, and then we already answered the, wait, is the IRS reimbursement rate sufficient for automobile use reimbursement?
I'm not really sure what the question is.
So the 72.5 cents per mile, is that sufficient for the automobile use reimbursement? No, it's only gas reimbursement, that amount. It's not for insurance and maintenance.
Right. It's not, yeah, it's not automatic in every situation. It's exactly.
Yeah, yes, Belinda, it does end at 11:30, but it will be recorded. We're sorry, we have a lot of questions. And required to, okay, so we have one more question and then that's it, okay? Are employers required to reimburse for cell phone use if the company has schedules, if in an app, if the employee has voluntarily elected to use the app?
It's a loaded question. If employer has computers on site where you can access that same thing through the computer, then arguably no, you aren't required. If they're using cell phones as a convenience.
Okay, so that's our last question. And we went, I mean, we knew we were going to go long because there's a lot of new things. And with close to 300 people registered, almost 200 people here, it was long. We appreciate everyone who stayed on. We will send out this slide after we fix a couple of them because they were out of order and we put the Chamber's logo back on it. And we want to thank Kristina for this information. I want to recommend to everyone that you save the chat. So go up to your chat, you take the three dots and then you click save chat and just go somewhere on your computer. Everyone's computer is different. We probably, because I prefer to send this out together with the recording. So you're probably going to get it on Monday, but we're going to try to get it to you late tomorrow. And with that, you're free to roam the country and I'm going to shut off the recording.
Thanks, guys.